In this video, I'm going to talk about whether a driving offence will appear on your criminal record. So the rules apply for things like speeding, drink driving, dangerous driving, any other driving offences you might think of. We'll cover 4 topics in the video. Firstly, whether you will get a criminal conviction for a driving offence, then whether that conviction will go on your criminal record. Then we'll talk about spent convictions and how long you have to declare convictions for. And then finally, the topic of DVLA records. So we'll dive straight into criminal convictions. If you go to a criminal court in England or Wales and you're guilty of anything, then you get a criminal offence. You get a criminal conviction. So any criminal offence, you get a criminal conviction. So that means that if you plead guilty to speeding and you're given fine and penalty points, then you have a criminal conviction if the case was dealt with in court. Now, a few things are not criminal convictions, and those are really things that happen outside court. So if you've got a driver education course, for example, a speed awareness course, that does not count as a criminal conviction. Parking fines are not criminal convictions. Fixed penalties are not criminal convictions. So a fixed penalty from the police, 3 points and £100 for speeding, for example, excuse me, is not a criminal conviction. Also, cautions are not criminal convictions, but they do go on a criminal record. So remember the basic rule that a criminal conviction is anything dealt with by a criminal court, so Magistrates Court or a Crown Court. Now, not all criminal convictions go on your criminal record. So a criminal record is different from a criminal conviction. And the basic rule with criminal records is that only offences that are imprisonable go on a criminal record. So that means offences which technically you could go to prison for will create a criminal record. There are 1 or 2 others, like failing to provide a roadside breath test, that go on a criminal record as well. But by and large, the rule is that it's imprisonable offences only. Cautions also do go on a criminal record if they are for an imprisonable offence. It's fairly unusual actually to get a caution for a motoring case anyway. So just to give you a few examples, the list on the left with the red crosses, those are offences which are not imprisonable, and so you will not get a criminal record, even though you do have a criminal conviction. So speeding, careless driving, construction use offences, things like using a mobile phone, having a bald tyre, failing to observe a traffic sign, things like going through a red light, and then failing to provide driver details. Whatever happens with any of those, you could never ever go to prison. So they're not imprisonable offences, and so you do not get a criminal record if you're convicted of any of those, even though you do have a criminal conviction. The ones on the right-hand side with the green ticks, they are all imprisonable offences. So technically you could go to prison for drink driving in a serious case. So you do get a criminal record. Same thing for drug driving, fail to provide a specimen, dangerous driving. There's also failing to stop and failing to report an accident on there. Lots of people are surprised that in fact you can go to prison for failing to stop or failing to report an accident. So it's very important if you do have an accident to stop and give your details or report to the police within 24 hours. Now, criminal records are important because that's the DBS check. So if you're applying for a new job or something like that, and you have a criminal record check, these are the things that will appear on your criminal record check. But they don't stay on your criminal record forever. And there are some rules under legislation called the Rehabilitation of Offenders Act 1974. And so various different offences disappear off your criminal record after a certain period of time. And the rules are quite complicated. I'll show you how complicated they are in this next example here. So in this example here, there are various different rehabilitation periods for different things. So here's the example. So if somebody goes to court and they plead guilty to drink driving and no insurance, they're given a fine, they're banned from driving for 12 months, and their licence is endorsed for the no insurance, although they don't get points. The different rehabilitation periods are 12 months for the fine. So that means after 12 months, if it was just a fine, you wouldn't have to declare it anymore. Driving ban is 5 years from the date of conviction, so 5 years from the court date, and the endorsement is 5 years from the offence date. So you can see just in that simple example, there are 3 different rehabilitation periods, and so the whole case takes the longest one. So the longest one in that case is 5 years from the date of conviction, which means all of this case would still have to be declared, and you would not be rehabilitated until a period of 5 years from the date that you were in court. Now, those rules apply for most criminal record checks, but there are things called excluded positions. And if you're applying for example, for a job in an excluded position, then the Rehabilitation of Offenders Act rules don't apply, which means that you have to potentially declare your conviction forever if you're applying for any one of these things. These are some examples: working with children, working with people in vulnerable circumstances, that might be people with poor mental health, the healthcare professions, working in law enforcement, the legal system, firearms licenses, taxi licenses, that kind of thing. It's a big list. So those things will never, if you're applying for one of those things, then your criminal record will never disappear under the Rehabilitation of Offenders Act. You will always have to declare the criminal conviction. But there is a process called filtering, and some things can be filtered out even if you're applying for one of the jobs on the list. It's basically after 11 years, and if you've only got a single conviction, that can be filtered off. The rules are quite complicated. There's a charity called Unlock. If you have a look on their website, then there's some good information there about how you can work out whether your offence is going to be filtered. There's also information about rehabilitation periods on there too. The last topic I'm going to cover is DVLA records. So DVLA deal with things a little bit differently from a criminal records check. So these are the things that used to be printed on your license when they had paper licenses years ago. Now, if you go online and look on your DVLA record, you will see that they have records of endorsements, penalty points, and driving disqualifications on there. In general, most things stay on your DVLA record for 4 years. So it's 4 years for penalty points, 4 years for a disqualification, 4 years for dangerous driving, but it's 11 years if there's a drink driving or a drug driving element to it. That's basically because the DVLA need to know for 10 years, because if you get done for drink driving twice in 10 years, you get a longer disqualification. But so DVLA keep those records going for 4 years. That's a little bit different from the 3-year period. If you get 12 penalty points in 3 years, then that's when you could get a disqualification from driving for 6 months. But DVLA keep the records there, so they will appear on your driver record for 4 years or 11 years if there is a drink driving element.